Okay, welcome to the Unstable, our first annual post promulgation pre-enforcement of the Reformed Book 6 of the Code, of the Codice Juris Canonicis Happy Hour. We've got to do this every week. Okay, well, we originally were thinking of doing this for about 2 1-hour sessions. There's just not enough time left, so we're going to try to get the business done in under an hour and just hit the highlights. If we have questions now, that's fine, but later on, that's okay too. What I'd like to start with is just do a real short review of penal law, just because not the provisions, but more kind of what's happened since Vatican II, especially, just because everybody, even if you had it the last time it was offered, it was still a year ago. So nobody, I don't think, has done this real recently. And then what it was about the penal law and the 83 Code that required the reform that we're talking about now. And as you'll remember, I think everybody who's had Canon Law 1 will remember that the big sort of shadow over penal law is the clerical sexual abuse crisis, and that took up an awful lot of our time. Things we're worried about, that this is an important thing that the penal law is addressing, but also we have to be very concerned about the rights of the accused as well. And then we want to look at least the main high points of the reform itself. Okay, so penal law, just from 30,000 feet. The church has the inherent right to coerce the faithful who commit offenses. This is like a number of the church's inherent rights. The church has the inherent right to acquire property and to use property, and this is another one of the church's inherent rights. Probably doesn't sound too controversial because we're used to there being a penal law. But actually, after Vatican II, there was a movement to scrap all of penal law, to completely eliminate it, and to get rid of it entirely. And that didn't quite happen. There was a real debate about it, even among canonists. It went on for some amount of time. Penal law did survive, but like Jacob of old, it hobbled away after the struggle. We had 220 penal canons in the 17 Code, and that's reduced to 89 in the 1983 Code. The kind of along the lines of the decentralization that you see with Vatican II, that was in penal law as well, to leave more things to the bishop. And you see that in especially 2 features of the penal law. One is called facultative penalties, which are kind of optional penalties. You may remember that some penalties say there will be if so-and-so does such a thing, he may be punished by a just penalty. This formula, he may be punished, that's facultative. You could call it optional. The person might or might not be punished. And also indeterminate penalties. That's a just penalty. Doesn't tell you what the penalty is going to be. Doesn't say he's excommunicated. It's some penalty is going to be provided or should be applied, but it's not actually decided in the code what it will be. The idea is to leave that to the bishops. Well, what happens about a year after the 1983 Code is promulgated? You might be surprised to hear this, but the sexual abuse crisis erupts. You may be used to thinking of the sexual abuse crisis as dated to 2018 with the McCarrick report and the Pennsylvania grand jury report, or even 2002, where you've got the horrendous Boston cases and Los Angeles cases, the bishops meeting in Dallas of that year, out of which comes the Dallas Charter and Norms. But actually, the real watershed date is 1985. This is when the first widely known cases of abuse become known. The first one was a priest named Gilbert Gauthier in Lafayette, Louisiana. And the second case, I don't remember the priest's name, but the diocese was Fall River, Massachusetts. So starting then, 85, past and ongoing abuse is revealed. And we see first, based on these actual cases, Gauthier and others, how the church treats them. But we also see what happened in the past, because of course, as you know, this very sad story behind, seems like almost all of these cases. It's not, maybe not true of absolutely all of them, but that there often had been complaints. The person may have been sent to therapy, may have been counseled, may have had a meeting with his bishop, but was then put in another parish. Not saying it happened all the time, but it seemed to be a very, very common story. Well, why was that? What was going on was that these cases were being dealt with as kind of a matter of sin, or a pastoral issue, or kind of a therapeutic issue. So you've got sort of these ways that are really the preferred ones. Again, we're talking about at least from the time of the 80s for a while forward, but also looking back. And these cases, for the most part, are not dealt, I shouldn't actually say for the most part, as far as I know, almost never dealt with legally or canonically. Even though the crime, the delict, was a delict always under the 1983 code and the predecessor, the 1917 code. There's no gap where, hey, this was okay. It's always been criminal behavior. So why was that? Why did we have sort of a more therapeutic or something way of addressing this for the most part, and I hate to say it, but a real ignoring of the church's penal law? We'll go back to the debate after, in the late 60s, when we're starting to think about what the new code is going to look like that's going to implement Vatican II. As we just said, the big debate is whether to have penal law at all. It's not whether to streamline it. It's not whether to, shorten it or something. It's literally, we don't need this at all. That's at least one side of the debate. So that's there. But then also, the law has been weakened as well. As we say, it survives like Jacob, but it limps away from the fight. And so it's weakened in the sense of a lot less emphasis on it. Probably less prominent canonists going into it for that reason, though you still have some very accomplished names there. And up to some point, people believe that the problem of abuse, and we're really talking about especially abuse of children, but also adolescents. There was a belief that, or apparently, hopefully at least people believe this in good faith, that this could be cured. That if you truly repented, this could be cured in a spiritual way, but also if you were counseled, whatever the underlying problem is could be cured, whatever, medically, therapeutically, psychologically, whatever. And I think you could say, or at least assume, or at least entertain the idea that up to a certain, point, that likely was a reasonable assumption. That again, before maybe you would say before these cases became widely known. You might disagree with that. I mean, you could always fall back on saying, okay, maybe that's true. Maybe there is treatment, but why isn't the law being followed? The law didn't have an exception for go to the counselor or something. So that's still a problem, even if this therapeutic treatment was reasonable. I think if you do entertain the idea that up to a certain date it was reasonable or could have been reasonable to try to treat these issues in a medical or therapeutic way, um, I think it's hard to credit that view after 1985 because it really does explode. It really does. It really does explode. And three men. One was a canonist, one was a psychologist, and I think the other was a civil lawyer. I think they were involved in the Gauthier case in Louisiana, and they did this very long, I think it's about, if I remember, about 80, 85 pages memo that they circulated to all the bishops. So a lot of people who've really looked at this would say, at least from 1985 on, bishops really were on notice, which again makes 2002 and 2018 even more sobering.
Was it circulated outside the United States?
I don't think it was addressed to bishops outside the United States, but I think it probably de facto was available. So if all the bishops have it, then I think there must have been people outside the U.S. I mean, I've seen it, and I don't even know where it came from. I know somebody had. I don't know if you could find it online or something, but that would be interesting to.
Could we have expected most cardinals or John Paul to have read it?
I don't know. I mean, I would say U.S. I think the U.S. bishops were very aware, and I think it really seemed at the time, from what I understand, that there really was a. It looked like people were going to sort of get serious about this, and I think in some ways they did, but then I think also it died down to a degree as well. Okay. If you, those of you who are in Penal Law too, actually I guess nobody's. If you've done those of you who are in Penal Law too, but are working on the Penal Law writing project, you may have seen the press statement by Archbishop Iannone. Now he's the president of PSILT, the Pontifical Council for Legislative Texts, and he describes this era as one of really a confusion between justice and mercy. And then the secretary of PSILT, name familiar to some of you, Bishop Arrieta, says, now this is really interesting, I thought. They both gave statements when the Pope promulgated this new law we're talking about, promulgated on Pentecost. It's going to take effect in 3 weeks on Immaculate Conception. And Arrieta says, in the years immediately following the promulgation of the 83 Code, it became apparent that the penal discipline did not meet the expectations it had raised. Really interesting thing. There's maybe some question of the time frame he's exactly talking about, but he says immediately following the code. I don't know that he's necessarily talking about the 85 eruption of the crisis in the U.S., but he does elsewhere talk about Cardinal Ratzinger becoming extremely agitated about the problems with the 83 Code as early as, I believe, 1988, because again, Ratzinger has to deal with these in his capacity as prefect of the Congregation for the Doctrine of the Faith. Okay, so what happens? Again, Ratzinger is probably the most notable person who really notices this and really needs to find a solution. There was a provision when the dicasteries were reformed. There was a provision in that document, Pastor Bonus, that allowed certain crimes to be reserved to the Congregation for the Doctrine of the Faith, and this eventually went into, but they really weren't specified. They later would be specified, but it took some time. It really didn't happen until this document that you may remember if you've had Canon Law 1 called SST, Sacramentorum Sanctitatis Tutela, the protection of the sanctity of the sacraments. And so this document mentions 7 particular crimes that are so serious they're reserved to the Congregation for the Doctrine of the Faith, and the Doctrine of the Faith, CDF judges them. All of them except one are serious crimes against the sacraments, such as ordaining a woman, or attempting to ordain a woman, rather, and violations of the confessional, and then the one that's not related to the sacraments is the abuse of minors. Okay, so one change that we're going to see going forward is those of you I guess that's almost everybody, 3rd and 4th years, when we studied penal law, we had to study the code, but we also had to study SST. It's some other documents too, but SST was the most important one. Now with this reform, the key provisions of SST are incorporated into the new canons. So at least that part is going to be a bit easier. You're going to have the law essentially all in one place. So that's going to be helpful, even for those of you who've already studied it. It's going to still be helpful because it will be in the new canons. When we discussed, these are just some themes we discussed in Canon Law 1. Again, the abuse crisis created such a shadow over penal law. We're obviously very concerned with protecting the vulnerable and punishing abusers, but also very much with fair treatment of the accused. And so one of the areas we're going to, probably our main area tonight, I think, will be how have things changed for the accused. And there's actually seems to be some good news. So I think that's helpful. And I don't really think anything's being lost as far as protection of the vulnerable. I don't think it's recognizing the right of defense, but then taking a little bit away from the accused. I think that this part of it, if it's actually implemented, should be a real improvement. One of the things we also talked about when we talked about these accusations is how are they going to be judged? And there's 2 ways. They could be judged by a judicial process or trial, or by an administrative procedure. And the law really prefers the judicial process, and that's a good thing. ... because it's more protective of the rights of the accused. However, what started to kind of creep in under the 83 code, it's still with us, is allowing bishops and superiors to judge some cases, and eventually, most cases, administratively. In the abstract, there's nothing necessarily wrong with that. You could have an administrative procedure and still protect the rights of the accused. However, those rights and the stages where the accused can take advantage of having counsel, etc., are much better defined with the judicial trial or process. So one of the things I was interested to watch is, are they going to try to go back to the preferred, and it's still in the new law that it's preferred that there be judicial processes, but they're still permitting the administrative procedures. And really anybody who had a choice, anybody who was in authority and had a choice, probably would choose to do the administrative procedure. It's easier, it's quicker, uh, especially if it's an issue that has some time sensitivity. Uh, there's almost an infinite number of reasons that you would choose this if you could. It's basically just easier. I mean, I think if we're allowed to do it, almost everybody would do that. I was actually hoping there would be more of us setting back to requiring more of the judicial processes. There isn't, but there's some improvement even here. We also, this is kind of a different issue, still talking about some things we talked about in Canon Law 1. We talked about latae sententiae penalties. I know some of you are familiar with the canonist Ed Peters. He's a real hater of latae sententiae penalties. These are penalties that are incurred by the very act of, by the very fact of doing the deed. You're judged to incur the often called an automatic penalty, and a lot of people, not just people, a lot of people really dislike latae sententiae penalties. In the Eastern Code, we don't even have them. There actually aren't latae sententiae penalties in the Eastern Code. I've sort of wondered if we might see at least some reduction, and we don't. They're still there in kind of full force. If you want to talk about the reasons for that or speculate on the reasons, we can talk about that. I was kind of hoping there would be some movement there, but there really wasn't. In this same connection, though, when we think of latae sententiae or crimes that carry a latae sententiae penalty, probably the one uppermost in your mind would be abortion, simply because this is the crime or the delict you're not just most likely, but really certain to encounter at some point in your priestly ministry. It's extremely probable. What the code says, though, is that if certain factors are present, then even if you've done the deed, you've gotten an abortion, maybe you don't incur the penalty, even though you've had an abortion. And so you've got all these what are called mitigating factors in the code. This would be in 1323 and 1324 of the current code, but the code that's about to go away. And these mitigating factors have been criticized too, precisely because it creates uncertainty. Did the person really incur this penalty or not? For instance, with abortion, like a common one would be, she might be too young to actually have incurred a penalty, or she may have been forced into the action. So there's others too, but it's there's a number of things that reduce a person's responsibility. So you've got this strange back and forth of a person who may not even know there's a penalty, who has apparently incurred the penalty automatically, but there's this long list of factors that if any one of them is present, maybe she didn't. And one of the things Peters complains about is that whenever a latae sententiae penalty comes up in the news, people shift entirely away from thinking about how serious the crime is and get into this procedural morass of, was the penalty actually inflicted? And I think he's on good ground there. As far as these mitigating factors, though, really, I would have really thought that these probably wouldn't go away, but would be reduced in the new penal law. But they're still there. They're mostly still there. There might be there are some changes, but they really have not been reduced. So these mitigating factors are still there, and the canons are the same. It's still 1323 and 1324. One of the things when we first started studying penal law and canon law 1 is we'd look at what are the purposes of penal law, or sometimes it's called the finality. What's the finality of penal law? And there's really three purposes or three ends. One, to restore justice or repair the disorder that's been caused by the offense. Two, to reform the offender, if possible. And three, to repair whatever scandal has been caused. And these factors kind of lead us into discussing the actual reform itself, because they're emphasized very strongly in the documents from the Holy See. Pope Francis himself expressly refers to every one of these three. Francis, however, talks about this issue also, and this is in his Apostolic Constitution, the short document that is promulgating the new law. He talks about this phenomenon of why do we need the new law, which we've kind of been discussing already. And he says there's been much damage caused in the past by the lack of understanding of the intimate relationship between the exercise of charity and the application of penal sanctions. Be an interesting thing to say, to connect penal law with charity. I think he's actually on pretty good ground, because again, you've got that repair of scandal and the calling back of the offender as key goals of penal law, not just getting justice, but these other two are very important and repeated over and over again. And Francis goes on to say that and this is probably the core of his reasons for the new law, that the correct application of penal law belongs inseparably to the pastoral office. We haven't been applying. This penal law has not been applied, and it needs to be. This is an ordinary thing, like the other stuff you do in your pastoral office. I'm addressing mostly bishops and superiors, but it's something I think all of us need to keep in mind. And he even goes on to say that negligence in using the penal system shows that a pastor is not fulfilling his office faithfully. Arrieta, in his statements in the press conference, says the new text, the new canons, seek to make the instrument of penal sanctions part of the ordinary form of pastoral governance. And this goes really along with our discussion in Canon Law 1, where we saw that you may remember in the, again, still current, but about to expire canons of books, the current Book 6, that penal processes are provided for, but they're really established as a last resort. It's after every other measure has failed, then, if all those fail, only then can the bishop or superior initiate a penal process. That was Canon 1341 of the, I'm going to call it the old law, the about to expire law. There's a similar provision in the new law, but it's phrased entirely differently. It may not sound that different, but it says the shoe's sort of on the other foot. The bishop or superior must initiate a penal process if these goals of penal law and the calling back of the offender, the restoration of justice, the repair of scandal, can't be achieved by other means. Kind of a subtle distinction, but it at least changes the emphasis. What else needs to change? Francis tells us right out. There has to be more determinacy and less discretion. And that's what we're going to find. That's going to be one of our big themes in the new penal law. More determinacy. We said there are these facultative and indeterminate penalties. If someone does such and such, there can be that type of penalty. That's gone. We're not going to have that. If there's an offense, there's going to be a penalty. It's not, there might be. there might be a might be if it's here's the offense and you can do these other things. There's some other penalties. There might be one penalty that's established and then some others that can be added on because of the gravity. But we're not going to have this. He's done the delict. There might be a penalty. He's done the delict. There's supposed to be a penalty now, and indeterminate penalties are still there. The indeterminate penalty is usually the just penalty. The so-called somebody does such and such a thing, the penalty is a just penalty. That still exists, but there's less instances of it. More of these are going to be tied to an actual specific determinate penalty in the code in the new penal law. What else is going to be new? More account is going to be taken of lay persons. You really see, when you read the current penal law, you hardly think of lay people at all, except as maybe somebody who's going to make a complaint. Because somebody who's an accused, it hardly even occurs to you. I think it's technically possible currently. That's going to be a greater possibility, and lay people are going to be mentioned in other ways too. Also, in the new law, there's an increased emphasis on financial crimes or crimes that harm church patrimony. That seems to be something, I don't know if there's a big trend here in the U.S., but it seems to be something that the Holy See is seeing a lot of. So they really put quite a bit of emphasis on it in the new law. And there's some additional, as we said, there's some more protections for the accused than there were in the past, which we'll discuss. Okay, let's look at the specific changes now in the upcoming penal law that will go into effect in December. First, I want to mention something about the numbering of canons. You may remember, if you had Canon Law 1, that we start out with kind of a general discussion of penal law, where we talk about the reasons for penal law, how you incur a penalty, what happens if you have an accomplice, how the penalties are lifted, kind of talking about penal law in general. And then the second big part of our penal law unit is about specific crimes and specific penalties. So it's kind of a very European type of division. You've got the general part and then the specific part. And we still have that in the code. One thing I'd say about the general part, and the general part would be canons 1311 to 1363 in the new penal law. 1311, 1311 to 1363. Those canons, they mostly have the same number that they did in the old law, the current law. So if you're looking for something in that area, if it's not in the exact same canon, it's probably only one off, but most of them are the exact same numbers. When you get to the special part, some of them have the same numbers, but there's been much more rearrangement. And it's kind of a more sensible rearrangement to things. I don't know if you've had to work with the penal canons very often, other than in Canon Law 1, but I often find there's just not that many canons. There's about 30 canons, 35 canons. I'd often just have to read through them all to find the actual canon I'm looking for, unless it's the last one, which is pretty easy to remember. Now it's organized much better. For instance, offenses against the sacraments, you had some of those in the code in different places and some in SST. Now they're all in one place in the new code. So the organization makes more sense. Also, I don't know if people out there sort of in the world would consider this important, but the Holy See considers this very important. They've changed. They took the the abuse of a minor used to be categorized as a violation of the special obligation, a violation of the cleric's obligation. Now it's put in a different part. It's called an offense against human life and dignity. So again, I don't know how much that's going to resonate with the public. Holy See considers that very important, and I think it is. I mean, if you sort of think the way that codes and such, or even the U.S. Constitution is organized, makes a difference. This really is. I think it's something that we can be pleased about. That it's raising the profile and raising the seriousness of the crime in some sense. Okay, this kind of maybe our key issue. I think that we may want to really focus on is the rights of the accused. How have the rights of the accused changed? I think there have been some real improvements. One is that this is going to sound surprising, but for the first time, we have an express presumption of innocence. It's actually stated outright that the accused is presumed innocent until he's actually proven guilty. That's in Canon 1321, Section 1. It's easy to be cynical about this and say, why does it take until 20 whatever this year is?
So repeat that one.
The canon number or the content? The content. So the content is that actually I don't have the quotation, but basically it says the accused is presumed innocent until Mr. Crabtree has it, and it is too small for me to read. So can you read it?
Yeah.
Yeah. Why don't you?
1321,
Yeah, 1321, Section 1.
You turn to 1321, Section 1. Any person is considered innocent until the contrary is proved.
Excellent. Yeah. Again, doesn't sound earth-shaking, but this is. I think this was really part of the church's ethos already. I think everybody who was asked would have said, this is what we believe. However, you may remember some of the sources that we read in Canon Law 1, particularly the Avery Dulles article and some others that really talked about how the mere accusation seemed to be stamping or branding priests as, I guess deacons too, but you just hear so many more cases about priests, but really stamping them as guilty. And add to that, and Dulles I think specifically mentions this, add to that if they're prohibited from wearing clerical dress as well, which is that's also discussed in the new law. So this I think really is important. Again, not that it wasn't there in some sense, but this is quite. I think it's quite good news.
Do you think it's to a sufficient degree?
That's a good question, I'm not sure if Mr. Clausen's question or Deacon Clausen's question came out. He asked, "Is this sufficient?" That's interesting. There's 2 or 3 measures that go right to, I think, helping the accused, and those I really think are very good news. Then there's some that are more indirect, but again, I think pretty good news. But I just had a conversation with Brother Peter the other day, who's writing on this subject. I don't mean to put you on the spot, but you're on the spot, Brother Peter. And we were talking about that, and so I think what we sort of, well, I'll leave it on Brother Peter in case he wants his 15 minutes of fame now. But one of the things we were saying, or I really think Brother Peter brought this up, was that let's see what happens with the Dallas Charter and norms.
With Norm 13.
Yeah. Norm 13. And when we talk about this kind of idea of presumption of innocence, and you've seen this in lists of accused that have been released to the press, that the phrase often used is this person was credibly accused. I think almost everybody would say that's a lower standard. That's much lower. If it's, I'm not sure it's even a standard at all, but it's not nearly the same as saying he's been proven, what we would say in our civil system, probably proven beyond a reasonable doubt, and in the church's system, another standard, which we'll talk about. So I think I'm kind of with Brother Peter. I think I might be a little bit more hopeful than Brother Peter. I'm not sure, but I think we're both. But I'm totally with Brother Peter in watching what happens with the local norms, the Dallas norms, but really obviously the versions of the Dallas norms that all of our dioceses and religious communities have now.
So, how do you think that is gonna? Where is it gonna come to a head with this new updated penal law and the question of publishing names, things like because that seems to fly in direct contradiction against the presumption of innocence, because whether they mean it or not, that's what they're saying is by publishing that you're not innocent, or we're not presuming your innocence, I think, or that even if that's not directly the case, that's the perception that everybody takes with them.
Yeah.
And so even if that's not their intent, that has to be taken into consideration. And so I think the practice of publishing names with that such vague language, and this new explicitly said presumption, I think they're incompatible.
That's do you agree with that, Brother Peter?
Mm-hmm.
Yeah, so if in case Deacon Clausen didn't come out, he said that the idea of presumption of innocence is incompatible with publishing names of credibly accused clergy, and I think and Brother Peter agrees. I'm not sure I'd say it's absolutely incompatible. I don't like the practice either, though. I don't like that practice either. I kind of think of a civil parallel, though. I mean, when someone is accused, people do know. I mean, people do know about it, and they still have the same problem of their reputation's harmed just by the accusation, which you're definitely right about. But this was all really compounded in the church, though, because a lot of these cases, these other factors we've been talking about, but a lot of these cases would drag on for not even just drag on, but not end. I mean, not end, and that makes it worse because it's bad enough that you're on the spot because you're accused, but if the time's clicking where you're going to in some period of time, in our civil system, we right to a speedy trial. I think we could use more of that in the canonical. And we do actually have something along those lines in this new reform. So I think there's some hope. I might be a little bit more hopeful than you and Brother Peter, but I totally I think have the same really the same concern. Okay. But again, I think even having that concern, I think we could agree that if we're going to have the matter resolved relatively quickly, that's certainly going to help. That's at least, and because the person's presumably going back into ministry too. That's the other thing, where you're accused and you're never heard from again. Like, oh, he must have really done something, but you're restored again. Not everybody hears about it. It's not perfect, but I think it's a big improvement. Deacon Horn.
Well, I don't think it's necessarily incompatible. I think clearly stating, not that there's been a judgment, but they've been accused of something in something specific, would go on to help our credibility and the trust in the church. Because I think that although an individual needs the presumption of innocence, the presumption of guilt we have well earned as a Catholic Church. Because of our track record over the last 50 years. And so from that perspective, I think if we're going to make real headway on taking this seriously, right? We all do virtus and this, that, and the other. If we're going to make headway about really protecting God's people, protecting God's children, then we have to be able to be transparent about what people were accused of, so that a thorough investigation can really happen. Because if we don't release names, like Indianapolis, if we didn't release Marcotte's names, then parents wouldn't know to ask their high schoolers who went to, was he at Roncalli, or parents wouldn't know to ask the Roncalli kids, did you hang out with this guy? Did you know him? Have you been alone with it? I think we're going to make headway.
Well, that may be the case, but I think what I would ask is exactly, and I'm up for being transparent, but I'm also up for keeping Canon 1717. And I would ask, how do we expect to keep 1717 and say, oh, well, the priest will restore his good name, everything is fine? It doesn't seem like you can do it once you've done it.
I don't think it can be. I agree with you.
But if it can be, then you have to erase 1717.
Which I might be an advocate for, but I don't think the priest's good name period can. That might be a longer view that I'm arguing, is that it's not possible in our current context, given where the church has been.
Well, what? Deacon Caldwell?
One big problem
Wait, speak up. Yeah.
One big problem is, what does it mean to be credibly confused? It is defined nowhere. It's nice thing. Canon law does not. And so if you have no understanding of what credibly accused means, because at least for a trial, to sit there and say someone's accused, they need to be subpoenaed. In a civil trial, it needs to be subpoenaed, and they need to have probable cause. Not subpoena, sorry, indicted. Get my terms right. They need to be indicted with probable cause. To be said, a probable cause has a clear understanding and definition. You can challenge it. You can credible. Who knows? One person thinks it's credible. One person not. There's no definition. And I think that's where comes the problem. We had a clear understanding of what does it mean to be credibly confused. Is that probable cause? Oh, we're in business. We don't have that.
Yeah, good. I think some really good observations here, and I don't think this revision solves them all, but I do think I think it is going to improve them if these provisions are implemented. And I think Deacon, I'm not totally sure that it came out on the recording, but I think Deacon Caldwell made a good point. Well, one is, do we know what credibly accused means? What it seems, unfortunately, to have come out in the wash as meaning is not manifestly untrue. So essentially, this could be true. This is something that could be true. Essentially, not made by an insane person, not accusing me of something that happened in Lubbock, Texas, when I've never been to Lubbock. Something like that. That some people have been fortunate to be able to disprove and to get the accusation judged non-credible there. But for the most part, most accusations have been assumed to be credible. Deacon Clausen.
Are there any mechanisms in the code about that the code speaks to about restoring somebody's good name?
That's interesting. So Brother Peter was concerned with this idea of that we've got, as Brother Peter said, in Canon 1717, but we've also got it in the Dallas norms. It's in the Dallas Charter and norms too. This idea of protecting or restoring the good name of the accused. Yes and no. We've got one of our canons in our Bill of Rights, Canon 220, says that everyone has a right to their good name and to privacy. And then we've got these sort of statements in the penal law and again in the local penal law referring to protection or restoration of a good name. But again, how can those be actualized if we don't bring the actual case to a close? And that, I think, fortunately, is something that the new law does address.
You know, about the case that Ben brought up, you know, my thought is, you know, they inevitably get to the news. They inevitably get out to secular sources, and you know, they don't always portray them in the same light that the church does. And so, you know, I think one thing that I could see is like, okay, if we send, however we inform the church or the parish or the people, that's fine. But then there needs to be some way of informing the secular surrounding area when this issue comes up in the news. Like, you know, it was on Thursday night's channel, 10 o'clock news or whatever. That the church comes out and makes a response to say, this is exactly what we mean. And because I think a lot of times it kind of gets confusing for the church, or for people who are not in the system of the church, about what all the church says and means. And so that was something that I thought of, like, okay, well, if we're going to accuse somebody, it ends up in the news, okay, then let's, you know, have some vehicle to say, okay, that the bishop or, you know, whoever is going to go on the news, make a statement about this is what he's accused of, to what degree, you know, that kind of thing.
Mm-hmm.
To be fair, it's confusing for people in the system too. That what that is.
Yeah.
Just left the penal code at this point. But I think it's the problem of bishops acting as managers and dioceses acting as corporations. Instead of acting, they don't pass particular law, they give guidelines and policies.
You just have to be
But we
Oh.
have now left penal law, which I think we want to get back to.
anyway, sorry.
No, really interesting. Well, I mean, this is one of the reasons we're focusing on. We're not going to be talking only about rights of the accused and protection of victims and vulnerable people, but this is probably the most important thing we need to address, and that you need to be aware of. On this issue of the sort of the credibly accused standard, the thing, and I'm actually surprised that this next thing I'm going to mention has not received I don't think it's received as much attention as maybe it deserves. But this is this is in the new canon 1342, and what it does is most of that canon is the same as the old one, and it talks about putting in motion the kind of penal machinery, but it also says that it says that there can be use of the judicial process is preferred, but the administrative procedure can be used. So, stab to my heart, but it's in there. However, it really improves things, because it says the right of defense, though, has to be provided essentially as if it were. In fact, it cites a canon close to the one that Brother Peter mentioned, Canon 1720. The right of defense has to be protected. It doesn't quite, what I'm about to say now, it doesn't quite say this, but I think this is the implication, as if it were a judicial process, as if it were an actual trial. And then it actually gets even better. It says, and keeping in mind that whoever decides the case has to have moral certainty. And that's what you do if you have somebody you know has a nullity question. They're seeking nullity of their marriage. The judge or judges they can only find the marriage null if they have moral certainty. And that's a fairly high standard. That's a pretty high standard. That's not just more likely than not. More likely than not is called preponderance of the evidence. I've got 2 witnesses. Mr. Crabtree has 1, and did I actually run over his dog? Maybe I've got 2 witnesses, so maybe I win, even though I'm notorious as a dog hater. So in like a civil case, all you need is a little more evidence than the other person has in a case between private parties. But when the state is trying to convict you of a crime, in the civil sphere, it needs to establish guilt beyond a reasonable doubt. So preponderance of the evidence, or Mr. Crabtree sues me for running over his dog. He only needs 51%. He only needs 50% plus a scintilla of something, 50 and 1/100, just slightly more probable that I did it than that I didn't do it. But if the state comes after me as a dog serial killer, then they need to demonstrate that it's beyond a reasonable doubt. And it's hard to quantify what that means. Probably most people would say in the neighborhood of 80, 85, 90%, something like that. There can still be a doubt, but it has to be a reasonable doubt. It's me saying, no, I was beamed up by a UFO, so I couldn't have run over the dog, even though it's my tire tracks. That's probably not a reasonable doubt. It's a doubt. I've got a story. I've got knowledge. That's my story. Probably not. Most people wouldn't consider that a reasonable doubt. The churches here, what we've got, moral certainty, much closer. Probably not as high as beyond a reasonable doubt, but fairly close to it. Probably much closer to beyond a reasonable doubt than to just a preponderance of the evidence. So this is really saying it's got to be proven, and be proven with some elevated amount of convincing evidence, not just more likely than not, but so the decision maker can have moral certainty that the accused has actually done this. If this is actually really implemented, this is applied in the norms as Brother Peter is suggesting really needs to be the case, and I don't say you can really argue with Brother Peter there. This is really a good thing. I think this is really some light shining in this area that it has been much needed for a long time. And maybe we've got Cardinal Dulles up in heaven who's achieved some of this for us on the spiritual realm. So that I think is really something to be grateful for. We have to be kind of vigilant to see what's actually going to happen. But let's kind of watch that. Okay. This is something that's in the same sphere, but kind of indirect. And another new development is that it's sort of part new, part not. There's these things you might not even remember from Penal Law 1 because they don't get too much attention. I don't think there's much scholarship on them at all, but they're called penal remedies and penances. And essentially, that's something less than a penalty. So you're not convicted of a delict, but you might be in danger of committing a delict. You maybe only didn't commit it because somebody walked in on you or something, or you are just have some very imprudent behaviors. So what these penal remedies and penances do, they can be a warning to you. They can even be a correction. This is in the current code, and it's going to be, but there's something going to be added in the new provisions. So these are the reason you may not even remember them from Canon Law 1, is I don't think they've been used very much. And they're just kind of out there as possibilities. But it's good to note. It's good to note that they're there. So the ones that we've had are the warning and the correction. What would that look like? The warning, I think we know it would be you getting yelled at by the bishop. What would the correction be? I'm not sure. Something stronger than that, though. Or it could be the situation where you've committed an offense and you've been punished for it. You've done the penalty, but now you're in danger of doing it again. This is another situation where you might have a warning or a penalty. What's new is there's two additional measures. One is the penal precept. Now, these already existed in the code, but it's provided that if you've been warned or corrected and you haven't changed your ways, you hang out with people you should not be hanging out with, or you do other imprudent things, and I've warned you a number of times and you're still doing it, then there can be a penal precept. And that's actually the authority directing you to do a certain thing. So it's almost like a law applied just to you. That this is, now if you do this, you're not kind of going against the fatherly admonition. You're essentially in the situation of breaking the law. But then there's another one too, called the measure of vigilance. And this is in a grave case, and again, if the offender is in danger of relapsing, maybe he's either done something or come close to doing something, maybe he was okay for a while, but now he's in danger of relapsing, there can be this measure of vigilance. Why I think these are good news, they might sound like bad news because they're additional things your bishop or a superior could do to you. So how could that be good news? I think it actually is good news because one of the reasons for leaving accused priests on ice for so long is, well, what else can we do with them? Maybe we can't prove guilt, but we don't dare have them at a school anymore or around children or something like that. These are some almost like middle areas where you've got a measure of vigilance. We don't have enough. We can't prove you've done this. You're entitled to a presumption of innocence. It's like under the code. We can't convict you, but boy, there have been some calls. This doesn't look good. You're going to be working at the chancery now. Your office is next to the bishop now, and that's not in the nature of a promotion. That's in the nature of people watching you. Something like that it's not, I think that's good because it's providing some answer to people who say, well, we've got to leave the priest on ice because there's nothing we can do. It's either return them to full ministry, back to the parish ministry, or else leave them on ice. And I think these measures, these new penal remedies and penances provide some other answers to that. Okay.
To what degree are those public?
Oh, good question. Probably, so the question is, to what degree would they be public? Interesting. They can't be public at all if the offense isn't public. And to some degree, they're going to obviously be public if I'm the pastor and I'm pulled out. At least maybe not that I'm why it happened, but that I was here and I didn't come close to serving my 6 years. I was there 14 months and now I'm gone. The people with brains are going to see that something's probably not right there. But I think they would be, again, they can't be made public if the offense or the cause for concern isn't public. I think the idea would be to keep them more on the quiet side, but it's not specified. Good question, but I don't think it's really specified directly.
Just gonna let you know, it's 8:35.
Okay, are they closing?
No, it's just
We close at 9. We can stay open
Okay.
close at 9, but just letting
It's
you know.
been an hour.
Okay, good. Let's just do a couple more points. We've done quite a bit. Do you want to end it here, or do you want to go 5 or 10 more minutes?
Another 5 or 10.
5 or 10.
Yeah,
Yeah,
Okay.
keep going. 10
Okay.
minutes.
Okay, we've got the penal remedies. Okay. Last measure that is good news for the accused. Probably. This is a new Canon 1362, Section 3. What it seems, 1362, Section 3. What it seems to say, it's really, don't bother reading it because it's kind of impossible to tell what it's saying. What it seems to be saying is that the penal case has to be resolved within 3 years. So that's how it's been reported. That's how people are describing it. So this, again, really good news. I mean, I know that's a long time. That's a long time to be on ice. It's not 18 years, though. I mean, it's not. I know I had 2 priest clients that were both, and then it was for nothing like this. Nothing like this stuff. I mean, it was essentially for disagreements with their superiors and, if anything, very minor things. Both 5 or more years were out of ministry. So this 3 years, again, that's no walk in the park, but this is quite good news. The implication seems to be that the penal process has to be resolved within 3 years. I'll tell you, sometime I'm hoping that's how it's going to work out. There is a provision there that says, but there's some delicts are reserved to CDF. However, I think this is still going to apply to those. But anyway, that's how this has been discussed. This seems almost like a kind of a speedy trial provision or something like that. I hope that's how it works out, Mr. Kite.
I feel like they could leave the door open for potential. So if it's not resolved within 3 years, then it just kind of sticks. There's not an actual. I don't know if that's.
Well, that's actually partly true. So Mr. Kite's concern is that maybe that doesn't clear them. That is sort of true. If it's not, though, what it looks like happens is the prescriptive period, the time within which you can call the man to account, that starts to run again. So at least he's ticking off time and getting to the time where he'll be out from under that shadow. And you may have remembered that CDF could derogate from prescription. Essentially, they'd have a prescriptive period, and then CDF could lift it in some cases. The code doesn't talk about lifting it. Now, again, it does say there's special measures for CDF cases, but for these abuse cases, I think it's got a flat rule of 20 years. Again, that's a long time, but we've seen some of these lifted in the past, so this again might be an improvement for the accused. Okay, leaving aside rights of the accused. Yeah.
With the 3-year speedy trial time frame that we're hearing about in this section, would that include the time of a civil trial as well as a canonical trial?
Good question. We don't know yet.
Okay.
In fact, I went to a conference this summer on the new law. Somebody asked that exact question, and the guy who was giving the presentation is a German priest from Peacehilt, and he said that hasn't been worked out yet. But good question. Good question.
Even if a civil trial is lingering.
Well, a civil trial, at least. I mean, again, at least the civil trial's on a certain clock. I mean, I wish we were more sort of on that kind of railroad clock mentality in canon law as the civil is. But again, I don't know. Maybe so, but I don't think we know the answer to that yet. I think. Yeah, I don't know. And again, I'll look at my notes again because I remember that specific thing was raised, but I don't think that this Monsignor had a response for it other than don't know yet. We mentioned that there's more emphasis on the laity. I told you one thing was that the laity could now be, I think I told you, that could now be suspended. It used to be suspension, it used to be a penalty that applied only to clergy. Now the laity, if they hold an office or function, they can be suspended. And you may remember the crime of attacking the Pope or a bishop. For the Pope, you get excommunicated. For a bishop, it's interdict. For a cleric, it's a just penalty. Now, if you attack a lay person out of hatred for the faith, you're also punished with a just penalty. So if you have any lay professors you want to take a poke at, you've got about 3 weeks. Otherwise, you're subject to penalties. So get your.
But it's only out of hatred for the faith, right?
Oh, right. Just don't like the look of your face. Have at it. Yeah, that's what I'm most worried about. So, and again, I think it's a good thing because I think that we had a sense of unreality about the penal law, where it only applies to a fraction of the members of the church. And again, that's still the case because this is mostly talking about laity who are in some position of responsibility in the church. But I think this is good. It just makes sense. Laity doing more things in the church, that they should both probably have this protection, but also be subject to suspension. Some new delicts. Again, I won't go into the patrimonial crimes in too much detail, other than to say that seems to be something that's really on the Holy See's radar. The one I'll mention, though, is that so there's just more emphasis on that. If you're required to do a consultation before selling or alienating property and you don't do it, that's a crime now. But also, if you request an offering beyond